Good day, Sir Gilbert, and good day, classmates. We are Group 5, and our assigned topic to discuss is the right to form union and to strike, and the fiduciary duty of employee. So, I am Jeffrey Padin, and I am here to discuss the first part of the right to form union and to strike. The relationship between the employer and the worker is not always smooth and harmonious. Since the employer is usually more powerful than the worker, there is a need or necessity for mechanisms that would render support to the plight of the workers. So as it seems, in a certain occupation in a company, the employer or the boss are usually the one in charge of giving commands to employees, meaning that a certain amount of time they would probably gain dominance over their subordinates that he or she holds. But, in order to enforce the equality, there are many laws and rights provided for the employees in order to also gain the invoice and be heard by their superiors. One of these is the right to form union and to strike. To simply explain, this right is comprised of two actions, the right to form union and the right to strike. So the right to form union is the Constitution in the Industrial and Labor Relations Act that provide freedom of association and allow workers and employees to join and form unions. When we say union, it is a club, society, or association formed by people with a common interest or purpose, meaning that a union is a gathering of certain persons with the same interests that wants to be heard by people in order for them to have them agree on the terms that they want to have. Then the next one is the right to strike. It is a fundamental human right, and it gives workers dignity in employment and the right to protest without fearing for your job, your home, and your family. It is what separates workers from serfs. The coalition has indicated it is willing to restrict existing strike laws. So when we say a serf, it is a person or a family status in which they are servants of feudal lords with minimal rights and cannot complain or protest about it. Company rules and regulations are just a normal case for most organizations, but stepping over the line of ethics is what makes it unfair for employees. So they are provided rights to form union and strike without fearing of job loss and many other kinds of threats. As the employees make their own group of the same interests, it is called labor union. Relating to what I said earlier, labor union is an association of employees that advances member interest through collective bargaining with an employer. Areas of negotiation typically include wages, benefits, work dues, etc., and it is one of the most effective mechanisms that gives power and leverage towards workers. It assures that they are not exploited, abused, and subjected into human working conditions. So basically, union is a form of union that are composed of people that have their common concerns about their own job or their employer, making sure that they are both in equal terms and are not being abused to work in unethical or unfair ways. The right to organize is a part of the fundamental human rights enshrined in the 1948 United Nations Universal Declaration of Human Rights. Its 20th article states that everyone has the right to freedom of assembly and association, and our 1987 Philippine Constitution reiterated this right. Furthermore, the third article, or the Bill of Rights, declares that the right of the people, including those employed in public and private sectors, to form unions, associations, or societies for purposes not contrary to the law, shall not be abridged. Business owners have the right to form peaceful organizations to advance their interests as owners of businesses. And likewise, workers have also inherent right to form organizations to advance their common interests. That is why workers usually form labor unions in order to achieve their legitimate concerns and to participate meaningfully in matters that directly affect their lives as workers. Democrito Mendoza, a former president of the Trade Union Congress of the Philippines, summarized the objectives of a union in these words: decent work, decent pay, decent lives. This statement of him clearly supported the rights of the employees to have an equal payment as to what they'd perform in their jobs because as workers, he knows that their lives would most likely depend on to what they will receive from their work.
So good day everyone, I'm Plain Luis Magsino and I'm here to continue our discussion, and the assigned topic to me is about the main objectives of a union. And may tatlong objectives na nakalagay dito, which is yung democratization of wealth, democratization of power, and humanizing the working class. So, bago natin i-define yung tatlong objectives na yun, let's define firstly kung ano ba talaga ibig sabihin ng union. So, ang union, base sa Google, ang sabi sa kanya is, it is the act of joining or being joined in an association. So, base sa pagkakaintindi ko, parang siya yung nag-join sa employees, sa employees, or siya yung ang union yung siya yung nag-join sa mga employee or at employer na magkaroon ng unity sa isang company. So, let's start na sa the objectives nito. Kung saan yung first nga niya is the democratization of wealth. And it refers to the labor union's objective of ensuring that the workers receive just wage and safe working conditions. A labor union must assure that the employer does not abuse and exploit the workers. So, democratization of wealth. So, yung wealth, hindi lang ibig sabihin ng wealth, kayamanan sa pera. Kayamanan din siya sa kalusugan natin. So, yung company, dapat i-assure nila na lahat ng employees nila ay safe and tama yung pagbibigay nila ng sweldo nila. And for the second one is yung tinatawag na democratization of power. Then, it pertains to the labor union's objective of balancing the power between the employer and the employee. In the absence of a labor union, the employer is generally more power than the worker. If there is a union, there is a sort of equality and interdependence between the employer and the worker. So, di ba may nalilito nga kung ano yung employer and yung employee. Yung employer, siya yung parang, siya talaga yung owner ng isang business. And yung ang iniibig sabihin ng democratization of power, ibig sabihin, pinagbabalance niya yung power or kaya yung karapatan ng isang employee at ng employer. Kapag daw kasi walang labor union, ibig sabihin, mas makapangyarihan talaga yung owner. Yung owner lang talaga yung magsasuggest, yung i-make tungkol sa business. And kapag may labor union, lahat ng nasa isang company, may karapatan silang magsuggest, o mimic, or kaya sabihin lahat ng gusto nilang sabihin para ma-improve yung business. Ganun daw pag may labor union. And in connection with this, Dennis Collins said, may sinabi daw si Dennis Collins na kung saan labor unions perform an essential equalizing function, leveling the playing field between powerful business owners and organizational managers who seek to minimize employees' wages and benefits and dictate workplace rules, and individual employees who lack the power of adequately represent their own interests. Unions typically arise in circumstances where employees are continually dissatisfied with wages, benefits, and working conditions. They counteract managerial power by providing a unified employee voice. And yung sinasabi ni Dennis Collins, base sa pagkakaintindi ko, na kung nga yung may labor union sa isang company or sa isang business, magkakaroon sila ng unity, magkakaroon sila ng equal na karapatan. Yung parang yung halimbawa may problem yung isang employee, halimbawa may problem sa kanyang sweldo, parang gusto niya magreklamo, yan. Kapag may labor union, magkakaroon siya ng way para makapagsabi sa kanyang employer o sa owner na magsabi na bakit ganun yung sweldo niya, bakit ganun ang kababa, bakit ganun. So, basta ang pinapalabas ng pag may labor union, equal lahat, equal lang karapatan ng employer at ng employee. And sinasabi din dito, they counteract managerial power by providing a unified employee voice. So, yun yung sinasabing employee voice, yung nakakaimik yung mga employee, yung hindi lang employer or yung owner yung nakakapag-suggest or yung bumabatas. So, mahalaga din naman na malaman ng isang employer o ng owner yung saloobin na kanyang mga employees kasi hindi lang naman siya yung gumagalaw sa isang business kasi mahalaga din yung mga employees niya. And kasunod din nito, through the labor union, workers can actively and meaningfully participate in the formation of policies and business decisions that would greatly affect their working conditions and their lives. Breaking from a culture of silence, workers find voice with the help of supportive labor union leaders. So, kadugso nga lang to nito yung kanina sinabi ni Dennis Collins na yun nga, makakaimik din talaga lahat ng mga employee if supportive talaga yung mga leaders or yung mga employers nila. Kasi halimbawa naman kung stricto yung kanilang owner, yung kanilang employer, tapos masyadong matapang, syempre, sino ba namang makakaimik doon, di ba? Matatakot na lang tayo. So, mahalaga din na maging supportive din yung employer or yung maging mapagpakumbaba sa lahat ng employees niya. And for the last objective of a union, it is the humanizing the working class, and it pertains to the function of the labor union to educate the workers, the employers, and the society as a whole with regard to the value of human labor and the dignity of the workers. So, yun nga, yung sinasabi naman dito sa pangatlong objective is humanizing the working class. So, ang pumapasok daw dito yung labor union para ma-educate niya yung mga workers, not just the workers, pati yung employers, kung ano yung mga dapat gawin, kung ano yung mga value, kung ano yung mga right value sa pagtatrabaho or sa pagtatrabaho sa kanilang company. And labor unions must not only be concerned with obtaining material benefits from the employers. Labor leaders must raise the consciousness of the workers with regard of their dignity. So yun nga sinasabi dito na must raise the consciousness of the workers with regard their dignity. So, yun nga, dapat iniisip din daw ng mga leaders or ng mga owners o ng mga employees yung kanilang mga employees. Kasi hindi lang naman din sila yung gumagalaw sa business. Kung walang employee, paano din gagalaw yung business mo, diba? And equally important is raising the awareness of the society in general. Ultimately, people must not consider laborers as inferior individuals. So, yun nga, diba? Sa isang business, hindi naman porket ikaw yung owner, ikaw na agad yung, syempre, ikaw may pinakamataas, diba? Pero hindi naman ikaw yung sobrang magmamataas. Hindi naman pwedeng isipin na lang natin na yung laborers or yung mga employees ay sila na yung pinakamababa or babastay na natin, uutusan na lang ng uutusan. Syempre, may karapatan din sila and kailangan natin i-respect sila. And yun yung dapat gawin ng isang leader. Kailangan nilang ilagay yung labor union sa kanilang business, sa kanilang pag-uugali para magkaroon ng unity ang employees at employer. That's all. Thank you.
Good day, I'm John Ismana and I will now continue the discussion. We all attempts to reach agreement between the employer and worker fail. The workers usually resort to a labor strike. Diba, tayong lahat gusto natin ng isang maayos na patakaran pag tayo ay nagtatrabaho. And we all know that all of us wants to have a good work. And in working, we face what we call labor strike. Labor strike means a work stoppage caused by the mass refusal of employees to work. To be more specific, the people don't want to work because they don't want their policies. A strike occurs when an organized body of workers withhold its labor force and employer to comply with its demands. To be more specific, the workers don't want to work because of their policies. In Tagalog, labor strike means pag-uwelga ng mga tao dahil sa hindi maayos na patakaran ng kanilang trabaho. Just as the right to organize and form a union is a basic right of the workers, the right to strike is a basic strike. So it means like yung mga karapatang mag-ayos at bumuo ng mga union ay isang pangunahing karapatan rin ng mga manggagawa. However, there are economic and social disadvantages when workers decide to stop working. Like an economic disadvantage, when a worker stops working, it may create a lost opportunity cost of loss of sales for the company. It's company's loss. That is why the right to strike must also be a tempered, conscientious duties of the workers. That is why it is important to show care to the workers and give their proper right as a worker.
Good day everyone, my name is Arian May A. Padua and I am going to continue the discussion about the right to form union and to strike. William Shaw. He cited the work of Austin Faguthi and Milton Gonsalves to explain the condition for a morally justified labor strike. So, nag-research ako about dito and may lumabas na tatlong argument. Ito ay yung the rights argument, last resort argument, and the marketplace argument. Sa rights argument, ang ibig sabihin nito that in favor of the worker strike is direct and convincing for many. All individuals have a right to not go to work in the morning. Sa last resort argument naman, affirms that workers are justified in striking when three conditions are met. Yung three conditions na to, yun yung condition na binigay ni Austin Faguthi and Milton Gonsalves. So here are the three conditions. First, there must a just cause such as unjust wages and minimum and inhuman working conditions. Ang ibig sabihin nito ay petty resentments or interpersonal conflicts cannot be the driving force. Instead, salaries or working conditions must be the driving force. Second, there must be a proper authorization from the members of the union and from the proper government body. This suggests that the employees must be in favor of the strike and have made well-considered decisions. The workers themselves must support or take the actions. And for the last one, the labor strike must be the last resort, meaning the attempts to find solution must have been fully explored or all attempts in the efforts by both parties had already been exhausted. They claim that using force as a last resort is ethical only when it is completely necessary and there are no other choices or alternatives. Yung last argument naman, which is the marketplace argument, is the rawest of the justifications for striking, and it answers the ethical question with economic facts. If workers can get away with striking, the reasoning goes, then they are justified. The argument is less flippant than it sounds. Let's proceed to the next slide. Some employers may view the labor union as a counterproductive and as a hindrance to the success of a business. Yun. Yung ibang employers, sinasabi nila na ang labor union ay nagpapabagal sa success ng isang business. However, building a healthy relationship between the employer and the labor union would actually in turn improve the workers' efficiency and productivity. Furthermore, a smoothly functioning labor union contributes to a steady workforce and a more stable economy in general. Thus, a labor union is a valuable component in the aspiration to reduce the inherent tensions between capital and labor. So, ang pagkakaintindi ko kasi sa labor union ay isa siyang organization na nagjo-join force or nagsasama para makakuha ng mas maayos or mas mainam na sahod, benefits at iba pa. As a result, the labor union can lead to a healthy workforce and a more stable company. Also, the labor union is a vital partner para mabawasan yung conflict between capital and labor. And that's all. Thank you.
I am Eliza Mayan Fahanilan, and I'm here to discuss fiduciary duty of the employee. What is fiduciary duty of the employee? Fiduciary duty of the employee, it is about involving the trust between the trustee and the beneficiary, in which it is about involving the trust of the company to its shareholder. If the employees have fundamental rights to ensure that their work and working condition improve their lives and well-being, they have also corresponding moral duties towards the employers that they serve. The basic principles that underlies the duties of the employees towards the employer is captured in what is now famously known as the theory of agency. The online legal dictionary defines the theory of agency this way: a consensual relationship created by contract or by law where one party, the principal, grants the authority for another party, the agent, to act on behalf of and under the control of the principal to deal with a third party. Ibig sabihin nito, kung mag-i-improve or kung nag-improve ang pamumuhay ng isang empleyado sa pamamagitan ng kanyang trabaho ay may karampatang tungkulin ang empleyado na kailangang gampanan sa kanyang employer. Ang ibig sabihin ng theory of agency, it is a principles that used to explain and resolve issue in relationship between the business principal and the agent. Ang theory of agency, ito ay isang napagkasunduan or pinagkasunduan na nilikha ng kontrata or ng batas na may punong guro na siyang may otoridad at napapasailalim nito ang ahente na siyang kumikilos sa ngalan ng punong guro upang makitungo sa ikatlong partido. The business owner is not always present to deal directly with customers, suppliers, government officials, and other stakeholders. The owner may be present, but it is also possible that he or she is not expert with regards to deals of his or her business. Hence, he or she hires employees and employees entrusted to do the business dealings in the employer's absence or because his or her lack of knowledge, skills, and expertise. The employee is called the agent of the business owner, while the business owner called the principal. The agent or the employee acts in behalf of the principal or owner. The agent, therefore, has specific duties toward his or her principal. Agency relation take on a special character when the principal is highly dependent on or vulnerable to the action of an agent has agreed to act on behalf of the principal. Ibig sabihin nito, hindi laging present yung may-ari ng business para makipag-transaction directly sa kanyang customers, suppliers, sa government officials at sa other stakeholders. Maaaring nandun naman yung may-ari pero wala siyang gaanong expertise regards sa details ng kanyang business. Kaya, nag-hire siya ng employee na kanyang pagkakatiwalaan sa bawat transaksyon. Maaaring kaya nag-hire yung employer ng employee or ng agent ay para mapunan yung pagkukulang niya sa bawat transaksyon. Or kaya naman nag-hire yung employer or yung may-ari ng employee ay dahil sa kaalaman at sa mga skills and expertise sa business. Ang employee ay tinatawag na agent ng business owner at ang business owner ay ang principal. Ang agent or the employee ay kumikilos sa ngalan ng principal or ng owner. Ang agent ay may specific duties towards his or her principal. Kumukuha ang isang agency ng espesyal na tauhan kapag ang punong guro ay lubos na umaasa or mahina sa mga aksyon ng isang ahente na sumasang-ayon na kumilos sa ngalan ng punong guro. That's all, and I hope you learned something from my report. And for more information, Ms. Bianca Magnaye will continue the discussion about the fiduciary. Once again, I am Eliza May ang Pahanilan.
I am Bianca Luis Magnay and I'm going to tackle about fiduciary duty. So, fiduciary duty is the legal and technical term to refer to the obligations of the employee to always act on behalf of his or her employer. The Latin root word of fiduciary is fidere, which means to trust. So, from the word itself, duty, it means katungkulan. So, fiduciary duty is ano po, katungkulan mo na pagkatiwalaan ka ng ibang tao. Kumbaga, dapat ipakita mo sa ibang tao na pwede ka nilang pagkatiwalaan. And then fiduciary relationship, it is the relationship of trust between two parties. So for example, lawyer ako and then client kita. So kailangan may fiduciary relationship tayo. So we need to trust each other, ganun po. And then according to John Bowatright, he discusses the three main principles of fiduciary duty: the candor, care, and loyalty. So first is the candor. Candor refers to the agent's moral duty to be always truthful and honest to his or her principal. So first principle is ito nga, candor. So kailangan honest ka every time kasi how will other people trust you kung wala kang katapatan sa sarili mo? So kailangan unang-una maging tapat ka sa sarili mo para pagkatiwalaan ka ng ibang tao. And then, the second principle is care. It refers to the duty of the employee to take good care of all the assets entrusted to him or her by the owner of the business. These assets include money and properties. So, from the word itself, care, alam naman nating lahat na kailangan dapat maalam tayo mag-alaga, pahalagahan or ingatan kung ano man ang mga ipinagkatiwala sa atin ng ibang tao. And then the last one is loyalty. Loyalty stands for the principle that directors and officers of a corporation, in making all decisions in their capacities as corporate fiduciaries, must act without personal economic conflict. So, loyalty. Itong last principle na ito is kailangan sa fiduciary duty, you need to know kung paano maging open and paano makisama sa mga kasamahan mo sa trabaho. Kumbaga dapat may pagkakaisa kayo and kumbaga walang personalan, trabaho lang ganun.
Good day everyone, my name is Sheila Mena Alcantara and I'm going to report duty of loyalty. The duty of loyalty is a very broad obligation that covers many things. If somebody is maligning company, a loyal employee finds ways in order to support, protect, and defend the company from malicious and false accusations. If an employee happens to find another work that offer bigger salary and benefits, a loyal employee does not simply leave the company, endangering its smooth operation. While it is the employee's right to leave his or her work for better opportunities, he or she must do so with proper coordination with the supervisor, the manager, or the business owner. Sinasabi dito na being an employee, you have your obligations to cover up many things when it comes to company where you are working. Lalo na sa mga bagay tulad ng maling akusasyon na hinaharap ng kumpanya na pinagtatrabahuhan mo or natin. Though it is employees' right to leave, kung makahanap ng new opportunity along the way, gagawin ng naaayon sa proseso o tamang proseso na dapat alam ng company, ng boss or what. Kumbaga, merong resignation tayo o yung mga employee na hindi dapat sila mawawala pag nagtatrabaho o aalis. Thank you po.
Good day, everyone. I am Luisa Meras, and I am here to continue about the discussion of fiduciary duty of the employee. Fiduciary relationship is considered the duty of loyalty mainly pertains to the employee's obligation to act in the interest of the beneficiary and to avoid taking any personal advantage of the relationship. The concrete example of the violation of this loyalty is when the employee acts in such a way that there is conflict of interest between that of the employer and his or her interest. This will be discussed further in the next section on conflict of interest. His obligation exemplifies the selflessness that characterizes a fiduciary duty in general. A director's duty of loyalty requires them to act diligently for the company at all times and to always act in the company's best interest rather than their own, not only when making decisions but also when refraining or preventing oneself from making business decisions is the obligation of loyalty required. Fiduciary duty is important because not everything can be stated in the contract between the employer and the employee. Fiduciary relationship exists primarily to enable individuals to give control of property, information, or power to other people without complete instructions, relying instead on trust. Fiduciary duty aids in keeping the integrity of the employee intact. When a specific business agreement is brought to the board of directors' attention, for example, any director who may have a conflict of interest with the deal is supposed to recuse himself from participating in the discussion. This is to protect both himself and the business, as a director with a conflict of interest can be tempted to behave in a way that allows him to profit directly from the situation. That's all. Thank you.